Hi everyone, thank you for tuning in to the Immigration Lawyers Podcast. Today I am analyzing an AAO decision recently adopted by the USCIS about L-1A intracompany classifications. It is a very interesting and significant case, and I will analyze what it means, how it was decided, how it can be differentiated from other cases, and what it potentially means for future cases. Please listen and send your feedback to my email, info@jqqlaw.com, or if listening on YouTube, provide your input in the comments section. I would like to hear your opinion about this case, its analysis, your experience in this area in the past, and if you see cases like this in the future, please email me and let me know how USCIS is dealing with this subject area based on this new decision. Welcome to the Immigration Lawyers Podcast. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult an immigration attorney for specific information related to your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. My name is John Khosravi and I am the host of the Immigration Lawyers Podcast. I also practice immigration law in Los Angeles, California. You can learn more information about me by visiting www.jqqlaw.com. On April 14, 2016, the USCIS issued a policy memorandum making a certain AAO decision an adopted decision. The AAO is the agency that reviews some appeals of cases denied by the USCIS. In this case, an L-1A petition was submitted by a U.S. company for a beneficiary, but was denied by the USCIS director, and the case was subsequently appealed to the AAO. The case originally happened and was decided September 13, 2013. And USCIS on its own volition decision. By adopting a decision, USCIS is establishing policy guidance that applies and binds all USCIS employees. These policy decisions are intended so that USCIS could use the reasoning of the decision for future cases. This was a really important decision, and the significance of it we'll be getting into. But to start, I want to back up and go over the basics of what an L1 case is. An L1A intracompany transfer, which is different from the L1B specialized knowledge case, is when an executive or manager of a foreign company is transferred to a U.S. branch, subsidiary, or affiliate, and there's specific regulations on how this relationship should look like. When that person wants to be transferred, they have to fit within the executive or management title, and that's what we're going to get into here in discussion of this case. The companies have to fit a qualifying relationship, as well as several smaller but very important requirements to achieve success in obtaining this non-immigrant visa status. The big issue that most cases I've seen have when reviewing AAO decisions and denied cases or RFE cases is how the USCIS analyzes whether the foreign employee is coming to the U.S. to become an executive or a manager. By far, I believe this is the biggest reason why these types of cases are denied. Unfortunately, the way these things are analyzed are quite vague. The petitioner has to describe how a person will be an executive or a manager, and a manager could be a functional manager, a general manager, or a personnel manager. And there's specific ways identifying and explaining what these roles are and what responsibilities and duties they are. But the requirements, regulations are vague and unwritten in a large part, and a lot of it comes from experience to know what the employee can do and can't do. In particular, the executive or manager employee is not supposed to be doing non-qualifying tasks. The easy way to explain this is they shouldn't be doing day-to-day operations that lower-level employees could do. For example, every company needs to have a secretary or administrator picking up the phones. If USCIS does an on-site visit and they see there's no secretary there and the executive is taking the phone calls, that means they're doing non-executive duties, and that's going to hurt their case. An analogy I like to use is think about the beneficiary in such cases as being a general in the military. The general doesn't go fight on the front line. There's privates and corporals and sergeants who do that. So the executive is a general. A manager could be lower level people, but there needs to be certain distance between the lowest level of employees that do the basic jobs as opposed to the manager who's supposed to lead or fit within various other categories of what a manager is. Our discussion today will be focused on that manager role, in particular the function manager. The function manager is a specific type of manager that does not supervise or control the work of a subordinate staff, but instead is primarily responsible for managing an essential function within the organization. The term essential function is not defined by statute or regulation. If a petitioner claims that the beneficiary is managing an essential function, the petitioner must furnish a written job offer that clearly describes the duties to be performed in managing the essential function. So they need to identify the function with specificity, articulate the essential nature of that function, and establish the proportion of the beneficiary's daily duties attributed to managing the essential function. A lot of this explanation of what that job is in the U.S. will be the same for executives or managers of other types, primarily explaining what the duties are, how they're executive or management and not administrative or non-qualifying tasks. And this includes providing a percentage breakdown as to how much of that weekly or daily or monthly work is dedicated to each of those kinds of duties. But ultimately, USCIS must determine whether the petitioner has demonstrated that the beneficiary primarily manage as opposed to performing the essential function. So this is the difference with essential function, is that you identify a function which you consider essential, and it shows that the manager is managing it but not performing the duties related to that task. So let's get into the background and details of this case, matter of Z-A Inc. In this case, there was a petitioner who was a subsidiary of a Japanese company. The Japanese company was quite large, with $900 million in sales, owning a research and development laboratory, 7 factories, and 9 subsidiaries located in Japan and 5 others in other countries, and over 1,500 employees. These details are very important because it differentiates this company and gives it a level of legitimacy that USCIS likes to see. The company imported, marketed, and distributes packaging solutions designed for medical, pharmaceutical, and food industries. The company established a petition in the U.S. to develop its U.S. market. Now, the essential function that was identified here was developing the U.S. market, and that's an important thing we'll get into as well. So, a new office was originally established in the U.S. That L-1A was approved. When time came to extend the L-1A, original new office L-1A being for a year and extended for additional 2 years, USCIS denied the case, and this was because the U.S. office only had 2 employees other than that manager. They had an administrative person and a salesperson. And this is almost always going to lead to a denial for L-1A cases. Very rarely does a low staff and low employee number in the U.S. result in an approval, other than a new office where they accept the fact that because the company is new, they need more time to develop their staffing levels. The claim that the petitioner in this case made, and the AEO surprisingly approved of, is that the U.S. petitioner said that its beneficiary was being supported by 8 staff members in the parent company in Japan. That means the U.S. company was using foreign employees to provide additional support for the U.S. company, meaning they needed less staff members in the U.S. to accomplish what their goals are and to keep the company going. Now, this has rarely been seen to be successful. The U.S. and sort of the policy of an L-1A and all the business visas and investment visas are to develop employment in the U.S. So it's very important that they see that it exists in the U.S. and for L-1A purposes that there's an organizational structure underneath the executive or the management that could support the manager and prevent them from doing the day-to-day aspects of the job. So why would AAO accept this decision, whereas in the past, and as in this case, the director denied it? Well, it needs to be differentiated clearly from the typical case. First and foremost, as we discussed earlier, this is for a function manager. And a function manager, as the definition went that I read earlier, doesn't require supervision or control of the work of subordinate staff. And this is what differentiates from other kinds of managers and personnel managers, as well as even executives who do need to have, for lack of a better word, management of some lower level executives or managers to show the hierarchy of the company. But having said that, with this new decision, maybe an executive may be able to use foreign employees and doesn't need to supervise people in the U.S. because in essence an executive isn't a supervisory position. It's the brains of the company. It's just giving guidance for other people to do the work. It's a little vague, and that's the problem that exists with the L-1A category, is the vagueness of how to describe certain job positions as executive and what an executive really means. But going back to the differentiation of this case from other cases, one, it was based on a function manager, but I think what helped the AAO was the actual facts of this company. First, the company, as we talked about earlier, is making more than $900 million in sales overseas, and in the 8 months that it was in the U.S. made $600,000. The dollar amount gives a level of legitimacy to the U.S. company, showing that it's not just the beneficiary did not just obtain a visa to come to the U.S. as a tourist visa to stay here, but was actually doing operations and making a lot of money. And that gives it a level of legitimacy that I think differentiates it from a lot of the companies who may be a new office and after the first year make $50,000, $100,000, barely enough to even break even. Now, the foreign company had more than 1,500 employees, again giving a level of international and multinational legitimacy. The U.S. petitioner did certain things right, which I've seen in other decisions and denials for other people's cases that they repeatedly fail to do, which is provide the documentation the USCIS sees as standard, which is proving the existence of the U.S. employees and the foreign employees through wage documents, through letters, providing an organizational chart that gives the exact employees' names, both U.S. and domestically and abroad, giving their minimum educational requirements, their salaries, descriptions, however brief, of what the job duties are. Now, this was not a personnel manager case, so it wasn't required to show the educational levels of the employees, either in the U.S. or the 8 employees that were being used abroad for these purposes. But the beneficiary, or the petitioner in this case, did provide the degrees, and although not necessary, it is a positive step to show that people that were working for him had science degrees, engineering degrees, business degrees, and it gives them much more legitimacy and more palatable for the director or the AAO to approve the case. Also, the decision that was given to us didn't show exactly how the petitioner did this, but they were able to easily establish that the beneficiary had functioned as a qualifying manager abroad in the past 3 years. And when looking at AAO decisions, the number one denial being proving that the beneficiary in the U.S. is going to be an executive or manager. After that, and along with that, at least half of the time, there's a denial also based on not being able to prove that a qualified management executive position was taken by that beneficiary when they worked outside the U.S. in the last 3 years. And the petitioner here was able to prove that, which is a positive. The less reasons you give for a denial, the more palatable it is for them to approve it when they look at the totality of the case. And totality is very important. We'll get into that a little later. Now, I think the hardest part of an L-1A or general L-1 petition is describing a detailed description of the job duties of the beneficiary in the U.S. And I think this is where the lawyering comes into place and differentiates those who do L-1As or are newer at it or are learning at it in the denials and the approvals, is properly explaining what the job duty is and not using superfluous language that could hurt the beneficiary and the petitioner. Here, the petitioner did the right thing and explained the duties and the percentages of time committed by the beneficiary for these responsibilities. But they did one mistake, and the director got him on that, but the AAO overruled. And that was, they said that the beneficiary exercises full authority over negotiations with customers and outside professional service providers. Now, negotiating outside professional service providers is sort of an internal thing of the company. I can understand that. But negotiating with customers is a red flag for executives and general managers or personnel managers. In this functional manager aspect, the AEO decided that it wasn't. And the reason is, negotiating in general is a duty of lower level employees that are doing sales, or why I think this was okay was because, and as is mentioned in a footnote in the adopted decision copy of the AEO decision, was that the AEO found that market development, meaning the foreign manager coming to the U.S. to manage the function of developing the U.S. market, was considered an essential function. But then it goes back in the footnote in the case and says, our decision should not be read to imply that this function is necessarily essential to all businesses. Now, my thought is, how do you distinguish which company finds importance in market development and which doesn't? Market development is always an essential function for any business. For my law firm, market development is essential. For an ice cream stand, market development is essential. For General Electric and Disney, market development is essential. So that's always going to be an essential function, and really any beneficiary coming from overseas should be a management, an essential function manager, because they're coming always in almost pretty much every case to develop the U.S. market. So the decision here is a big issue of how they're going to develop and explain this hole that's in the case. And I think it's a way for a lot of L1s to be approved rightly, especially if their staffing is low in the U.S. So this could really make the L1 one of the biggest non-immigrant categories and really change the game based on how this was kind of vaguely explained. They're allowing few U.S. employees, the use of foreign employees to make up for that, and allowing market development, which is a vague term, to be considered an essential function. So essentially, if you could develop the corporate relationships, prove they're doing business overseas and the company's developed enough over there, they should be able to get an L1 and an extension. But I go back to the details of this specific case and the facts of it, in which I went into detail already, but the fact that the foreign company is very big, it's rich, it's successful, it has a lot of employees, provided documentation that these employees are being paid, what their uses are, well-written petition. All these factors were going to have to be used to differentiate this case from other cases where someone has an office in Vietnam with only 3 people in it and they're sending a person here to develop a company. I would imagine USCIS would give a hard time for that case and use these facts of the development of the overseas company to do it. Now, what I've seen is when USCIS doesn't like a case and not going to get into the facts, they're just going to find fault with the explanation of the duties, management executive duties of the beneficiary in the U.S., and say they were either vague, which is a terminology they always use, or they're doing non-qualified activities with limited explanation of why it's vague or they're not necessarily not qualifying duties. And that could do an easy job of denying the case. Now, a person could do an AAO appeal, but that might take a year or two, when an L1 has the option for pre-and processing, potentially reapplying maybe the decision to make. But when reapplying or redoing a petition, there needs to be some sort of substantial change to justify that, at least according to how the regulations say a redo should be. To wrap up this discussion, this decision could be a very, very big deal. There's going to have to be a follow-up by USCIS in describing what their limits are, because as I discussed earlier, having market development be considered an essential function and allowing someone to come to the U.S. and use foreign employees as part of his organizational chart to show they're not doing non-qualifying tasks could open the room up for a lot more L-1As and huge growth in this. Now the EB1C category, which is the green card, which is essentially an L1 on steroids, it's reviewed with a much more critical eye, but it touches upon L1 stuff. It's unknown whether this exception that's been brought out could be used for EB1Cs for obtaining a green card. I think they're going to be more difficult to not accept that in those cases, but potentially it's worth to try to do that. And also, outside the essential function manager, could an executive use this reasoning? You know, an executive doesn't necessarily always manage and supervise employees beneath them. They give orders as the leader of the company, but they're not managing a person underneath them. And so could this be used for executives so that they could stay in the U.S.? Maybe. We're going to see. On my website, I review and provide synopsis of every AAO decision with regards to the L-1A cases and L-1B cases that come out. I'll keep you posted if I see any changes in the way these cases are adjudicated and how they view these cases. And I think it's going to be very important in the coming months to see what changes are going to happen. Probably there won't be a sudden shift in AAO decisions now because of the time lag to get a decision from them. But from actual petitions that I do and my colleagues do, I'll get a better understanding of how in practicality this is going to work. Potentially USCIS will not be open to accepting this more expansive view of the interpretation of the L-1A regulation. We will see, but it just made the game much more interesting. Thank you for listening. To learn more about this program, please visit www.immigrationlawyerspodcast.com. Also, attorneys can visit www.immigrationlawyerslistserv.com to learn more about special listservs for immigration lawyers that provide forums to discuss professional questions and issues and exchange information with other practitioners from across the globe.